you're the one who encourages you to audit them. Testing. Testing. The one who encourages you to audit them. Nah, man, this audio sounds bad, man. This audio sounds horrible. Testing. Oh, man, I wonder what the hell that is. Testing. The one who encourages you to audit them. Nah, man, this audio sounds bad, man. Let me see something. Hey, John D, long time. Oh, man, I wonder what the hell that is. Let me see something. Hey, John D, oh, no, it sounds... Alright, it sounds good on this end. It sounds good on this end. Let me see something. Hey, John. Oh, no, it sounds good. Alright, it sounds good on this end. Okay, I think we're on. We should be on now. Alrighty, guys. We have reviewed this in the past. We got to refresh and review it again. We're going to skim through it. We're not going to read it all in one take. However, we're looking at the Federal Rules of Civil Procedure. So let's see some of the titles they have here. Procedure for United States District Courts. Number 1, scope of rules from action. Scope and purpose. One form, one action. Alrighty, let's, for example, we click on, this is going to be an issue. Okay, there's no way for me to hit backspace. Yeah, this is not going to allow me to do that. Oh, okay, yeah, never mind. We're good. All right, so scope and purpose. So let's get to let's read through Rule 2. The rule modifies U.S. Code Title 28, former suits equity when not sustainable, USC 28, confirming power of the Supreme Court to make rules and practice in equity and unaffected insofar as they relate to the rule-making power in admiralty, and these sections together with 723B. Okay, rules. Number 2, reference to actions at law, suits, or equity at all statutes should now be treated as referring to the civil action prescribed by these rules. Number 3 is the rules follows in substance the usual introductory statements to code practices with which provide for a single action and mode of procedure with abolition of forms of actions and procedural distinctions. Representatives. Okay, all right, whatever. Let's just skim through it here. Let's skim through it. So under Rule 3 is commencing an action for summons, serving other process. Rule 5 is serving and filing pleadings and other papers. Rule 5.1, constitutional challenge to statute, notice, certification, and intervention. Rule 5.2 is privacy protection for filings made with the court. Rule 6 is computing and extending time for motion papers. Number 7 is pleadings allowed, forms for motion and other papers. Rule 7.1, disclosure statement. General rules of pleading, number 8. Number 9 is pleading from special matters. Rule 10, form of pleadings. 11, signing pleadings, motions, and other papers. Representations to the court, sanctions. Court and sanctions. Or Rule 12, defenses and objections. When and how presented. Motion for judgment on proceedings. Consolidating motions, waiving defenses, pretrial hearing. Hey, new normal. Rule 13, counterclaim and cross-claim. Rule 14, third-party practice. Rule 15, amended and supplemental pleadings. Rule 16, pretrial conferences, scheduling management. Guys, make sure you hit the thumb up, please. Rule 17, plaintiff and defendant, capacity public officers. 18, joinder of claims, a requested joinder of parties. 20, permissive joinder of parties. 21, misjoinder and non-joinder of parties. Rule 22, interpleader, class actions at Rule 23. Rule 23.1, derivative actions, derive from one another possibly. Rule 23.2, actions relating to unincorporated associations. Rule 24, intervention. 25, substitution of parties. Oh wow, substitution of parties. Okay, title 4, or is that title 5? Title 5. Rule 26, duty to disclosure, general provisions governing discovery. Rule 27, dispositions to perpetuate testimony. Rule 28, persons before whom depositions may be taken. Rule 29, stipulations about discovery procedure. Rule 30, depositions by oral examination. Depositions by written questions. Rule 32, using depositions in court proceedings. Rule 33, interrogatories to parties. Hey, Katie, how's it going? Rule 34, producing documents, electronically stored information, and tangible things, or entering onto land for inspection and other purposes. Rule 35, physical and mental examinations. Rule 36, request for admission. Rule 37, failure to make disclosure or to cooperate in discovery. Sanctions. Okay, Rule 38, right to a jury. You know what I'm going to have to do is I'm going to have to click on each one of these individually, open them up, print them all out, or locate a PDF that has them all. I don't care how many pages it is, 300 pages if it is, and I'm going to have to read through this all on my own time. I got to master this shit, man. The next thing I got to master is the courtroom. Okay. I'm not playing around with these POSs, these public official servants. We're going to take them down the phone line. We're going to take them down the ringer. So Rule 38, right to a jury trial demand. Rule 39, trial by jury by the court. Rule 40, scheduling cases for trial. Rule 41, dismissal of actions. Rule 42, consolidation, separate trials. Oh, hope you're doing well, Katie. Hope you're doing well. Hey, Robert, how's it going? Rule 43, taking testimony. Rule 44, providing an official record. Rule 44.1, determining foreign law. Subpoena at 45. That's another good one we should open up. You know what? We're going to go through them real quick. We're going to read all titles, and then we're going to start opening up boxes here. So Rule 46, objecting to a ruling or order. Rule 47, selecting jury. 48, number of jurors, verdict, polling. Rule 49. What was wrong with you, Katie? Rule 49, special verdicts, general verdict, and questions. Rule 50, judgment as a matter of law in jury trial, related motion for a new trial. Conditional ruling. Rule 51, instructions to the jury, objections, preserving a claim of error. Rule 52, findings and conclusions by the court, judgment on partial findings. Rule 53, masters. Rule 54, judgments, costs. 55, default judgment. 56, summary judgment. 57, declaratory judgment. 58, entering judgment. 59, new trial, altering or amending a judgment. 60, relief from a judgment or order. Rule 61, harmless error. 62, stay of proceedings to enforce a judgment. 62.1, indicative ruling on a motion for relief that is barred by pending appeal, Rule 63, judge's inability to proceed. Hey, I don't know why we got 9 people in here. We should only have about 1 or 2. The rest of you got to leave out of here and go to an auditor's channel where they gossip. Go watch a different auditor where they gossip. Here we're reading about rules of federal procedure, civil procedure. We don't need this many people. We don't need 9 people in here. We just need 1 or 2. The rest of you, please leave and go watch another auditor gossip about another auditor. Okay, Rule 64, seizing a person or property. Rule 65, injunctions and restraining orders. 65.1, proceedings against a security provider. 66 is receivers. 67 is deposit into court. 68 is offer or of judgments. Execution at 69. 70, enforcing a judgment for a specific act. 71, enforcing relief for an agent's non-party. Hey, no, what's normal? I'm just trying to be funny, bro. I'm just saying that it's a measly, we only have 6-7 people in here while we're doing important work. But if you go to another auditor, gossip about another auditor, he'll have 50 to 100 people in there watching. So the people, they want to see gossip instead of learning what we have to, which is the next step now. It's a courtroom, whether that be state or federal. We got to get with it. Okay, enforcing. So 71. 71.1 is condemning real or personal property. 72 is magistrate judges pretrial order. 73, magistrate judges trial by consent appeal. Okay, moving on to 77, conducting business, clerk's authority. Notice of an order of judgment. Number 78 is hearing motions, submission on briefs. Rule 79 is records kept by the clerk. Good one. Rule 80, stenographic transcript as evidence. I know I'm not pronouncing this word correctly. I forgot how to pronounce it. Rule 81, applicability of the rules in general. Removed actions. Jurisdiction and venue unaffected at Rule 82. 83 is rules by the district court, judges' directives. Rule 85 is title. Rule 86 is effective dates. Rule 87 is going to be civil rules emergency. And we have Rule A this is supplemental rules for admiralty or maritime claims and asset forfeiture actions. You guys know what asset forfeiture is. So scope of rules is Rule A. B is in personam actions. attachment and garnishments, garnished wages. So Rule C is in rem, actions, special provisions. That rings a bell. Rule D, pository, what's this? Petitory and partition actions. Actions in rem and quasi in rem, general provisions at Rule E. Rule F is limitations of liability. Rule G is forfeiture, action in rem. So, all right. So we went through those. Now we're going to ask what's normal. Which box do you want to open and get more in depth in? Which one are you trying to look for? Enforcing a judgment, is that the one you want to look at to start with? So what rule was that one? Let's start from the top. Let me start opening up some of these boxes here so we could get more in depth. So let's see. Well, let's see summons to begin with. Let's see commencing in action. Okay. So, commencing in action at Rule 3. Start from the very top. Rule 5 defines constitute filing court. What constitutes filing with the court? Rule 5E. Okay. This rule, now Rule 3, this rule governs the commencement of all actions including those brought by or against the United States or an officer or agency thereof regardless of whether service is to be made personally pursuant to Rule 4D or otherwise pursuant to Rule 4E. Number 3, with this rule compare formal, equity Rule 12, issue of subpoena, time for answer, and following statuses, and other similar statutes which provide a similar method for commencing an action. Title U.S. Code Title 28, District or 45, Former District Courts Practice and Procedure in certain cases under interstate commerce laws. Okay, or yeah, these are additional sources. Number 4, the rule provides that the first step in action is filing the complaint, right? Under Rule 4A, this is to be forwarded forthwith by issuance of a summons, and that's what we're reading here, and its delivery to an officer of service, which I think that's a sheriff or process server. Federal might be different than sheriff. But other rules providing for dismissal for failure to prosecute suggests a method available to attack unreasonable delay in prosecuting an action after it has been commenced. When a federal or state statute of limitations pleaded as a defense, a question may arise under the rule whether the mere filing of the complaint stops the running of the statute, or whether any further step is required, such as a service of the summons and complaint of their delivery to the marshal for service. Okay, so federal marshals, I believe, deliver federal summons. That's amazing. The answer to the question may depend on whether it is competent for the Supreme Court, exercising the power to make rules or procedures without affecting substantive rights. To vary the operation of statutes of limitation, the requirements of Rule 4A, that the clerk shall forthwith issue the summons and deliver it to the marshal for service, will reduce the chances of such question arising. Okay, great. So New Normal says, no wonder our servants are unknowledgeable and ignorant. Okay, yeah. Petit. Yeah, so tell me what number that is, what's normal. What rule number was that? Alright, so this was commencing an action under civil procedure. Now we're going to look at summons. Ooh-wee! This one alone is probably about... Oh no, this one alone is about 30 pages. Wow. Alright. I'm going to have to read this on my own time. Man, you know what, man? You know what? Now I got to print all this stuff out. or at least I gotta locate the PDF so I could read it off my iPad. This is gonna be a lot of fun. I'm gonna read all this shit on my own time, guys, and I'll point out to you the highlights, the meaningful, impactful stuff. You know what? With these big ones, with these big page ones, that like this one's probably 20 to 25 pages alone. You see, Rule 3, for example, Rule 3 was only one page. If you were to print it out, it's one page. Commencement, complaint. But Rule 4 is summons, is by itself, it's about 25 pages. So that'll take a little while to read. That being said, I could do single live streams about some of these big pagers, like this one right here. But we're going to go ahead and move on here to, alright, Rule 4 is summons. So, commencement of action, summons, serving other process, serving and filing pleadings, okay, constitutional challenge, privacy protection, computing, pleadings allowed, form of motions, and other papers. I want to read that one. Rule 7. Okay, beautiful. This one is a shorty. This is about a 2-pager. So pleadings, only these pleadings are allowed. Okay? So pleadings allowed, that's something separate from just the word pleadings, what I figured out. So pleadings, only pleadings are allowed. Complaint, an answer to a complaint, an answer to a counterclaim, designated as a counterclaim. Number 4, an answer to a cross-claim. Number 5, a third-party complaint. Number 6, an answer to a third-party complaint. And number 7, if the court orders, 1, a reply to an answer. B, motion and other papers. In general, a request for a court order must be made by motion, right? The motion must be A, in writing unless made during a hearing or trial. B, state with particularly the grounds for seeking the order. And C, state the relief sought, right? Okay, beautiful. Number 2, form. The rules governing captions and other matters of form and pleadings apply to motions and other papers. Okay, great. You see, here's the deal. Just like I figured out FOIA Act, and there's no FOIA officer that could tell me, confuse me, or try to play me. I know it like the back of their study. But now I gotta graduate from the FOIA shit. Now I gotta start learning the courtroom stuff. Okay? So I'm telling you guys, just like I figured out the FOIA and I'm close to almost like an expert on the FOIA shit. This is how I want to be in the courtroom. I want to be more knowledgeable than a bar associated attorney in the near future. It's not going to happen overnight. But I'm always hitting the books. I'm always reading behind closed doors. So, okay, beautiful. So now we're moving on here. We're going to get to that what's normal. Okay, beautiful. Disclosure statement, general rules of pleading, pleading special matters, form of pleadings, defenses and objections. I want to read that one, defenses and objections. See, like this one is seems to be like, oh, this one's not too bad, probably a 2-pager, 3-pager. Time to serve a response pleading. In general, unless another time is specified by rule or federal statute, the time for serving a responsive pleading as follows. A defendant must serve an answer within 21 days after being served with summons and complaint. Or 2, if it has a timely waived service under 4D. What was 4D? Wasn't that summons? Okay, within 60 days after the request for a waiver sent, or 90 days after it was sent to the defendant outside any judicial district of the United States. Who is the designated FOIA enforcer? You got to be the people, bro. B, a party must serve an answer to a counterclaim or cross-claim within 21 days after being served with the pleading that states the counterclaim or cross-claim. C, a party must serve a reply to an answer within 21 days after being served with an order to reply unless the order specifies a different date. Number 2, United States and its agencies, officers, employees sued in an official capacity. Okay. The United States, a United States or agency, or a United States officer of the employee sued in an official capacity must serve an answer to the complaint, counterclaim, or cross-claim within 60 days after service of the United States attorney. On the state's attorney. Okay, beautiful. So 3, United States officers or employees sued in individual capacity. A United States officer or employee for an omission occurring in connection with duties performed by the United States behalf must serve an answer to a counterclaim, cross-claim in 60 days after service. Okay, whichever is later. Number 4, effect of a motion unless the court sets a different time. Serving a motion under this rule alters these periods as follows. A, if the court denies the motion or postpones its disposition until trial, the responsive pleadings must be served within 14 days after notice of the court's action. Or B, if the court grants a motion for a more definite statement, the responsive pleading must be served within 14 days after the more definite statement is served. B, how to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required, but a party must assert the following defenses by motion. Lack of subject matter jurisdiction. I object. Your Honor, I object. Lack of subject matter jurisdiction. Number 2, lack of personal jurisdiction. Your Honor, I object. Number 3, improper. This is the improper venue. Insufficient process, insufficient service of process. Number 6 is failure to state claims upon which relief can be granted, and failure to join a party under Rule 19. A motion asserting any of these defenses must be made before a pleading if a responsible pleading is allowed. If a pleading set out a claim for relief that does not require a responsive pleading, an opposing party may assert at trial any defense to the claim. No defense or objection is waived by joining it with one or more other defenses or objectives in a responsible pleading or in a motion. C, motion for judgment on pleadings. Okay, all right. We'll read this at a later time, on our own time. Let's go ahead and carry on here. Okay. So what else did we have here? Counterclaim and cross-claim. Let me see what how do we force FOIA service handed over? The only force we can is I'm gonna file a complaint. No, you know, the thing is, bro, the thing is how you could fix it all up is you gotta sue them. You gotta sue these people. That's the bottom line. You gotta sue them. You gotta go dump the measly money. Salute to the person who gave me that $650. I still got that $650 withheld. And we're gonna file suit soon. What's normal? You're gonna see a suit real soon, bro. I'm not gonna tell you who, which agency it is, but you're gonna see it. You probably already know who it is. Sue myself? What are you talking about, bro? Amended and supplemental proceedings, pre-trial conferences, scheduling, plaintiff and defendant capacity, joinder, misjoinder. These sound like transsexual type shit. No homo. Interpleader, class action, derivative action, I think derivative action, if I'm not mistaken, let's use, for example, Puff Daddy. They say, oh, Puff Daddy's doing all that sex shit, but then they're trying to intermingle him with the Tupac murder. So they're saying, oh, well, this is deriving. Now this evidence is deriving into the fact that you have something to do with the shooting of Tupac Shakur. I could be mistaken. We'll read that at a later time. 23.2, actions relating to unincorporated association. Intervention at 24. Intervention is when you intervene. You become like a, Okay, duty to disclose. General provisions. Depositions, persons before whom depositions may be taken. Stipulations about discovery. Okay, depositions. Alrighty. Interrogatories to parties. I like that one. Well, I want to read this one. So this one right here seems to be that it's pretty short. Why should I have to sue our servants? Well, to get them, it's sad. Yeah, it's sad the way it's all set up. But interrogatories to parties. Number 1, unless otherwise stipulated in or ordered by the court, a party may serve any other party no more than 25 written interrogatories, including no more than 25. Okay, including all discrete subparts. Leave to serve additional interrogatories may be granted to extent consistent with rule number 26B 1 and 2. Scope: an interrogatory may relate to any matter that may be inquired into under 26B. An interrogatory. AT, the people are just catching on to FOIA. You're jumping into court. What's normal? What's normal? I'm going to tell you, I'm going to start yelling at you what's normal. I'm going to tell you to become the new fucking leader, to tell these subscribers to log off of my fucking page and go sit on an auditor where he's gossiping about other auditors, or go follow the auditor that's continuing to film post offices. Get off my site. He said, hey, people are starting to catch on. How many times do I gotta tell these measly people pick up the phones and start calling these fucking stores up? How many times do I gotta tell these people? You clearly hear me on the phone. Yes, ma'am, here I got the statue in front of my face and I'm doing the gig. He said people are still... What's normal? What's normal? Here's what I'm gonna tell you to do, my friend. I'm gonna tell you to remember what I'm telling you right now. Auditors, quote unquote, my fingernails, auditors are going to catch up onto FOIA auditing in about a year or 2 years. Give them about a year or 2 years before they start picking up on FOIA auditing, narrowing down. It's fucking so stupid. And like I said, I just made that up, like the theory, it's just like a joke that I'm saying, turn me into the secretary of all auditors, right? That's just like a figure of speech. I'm just joking about that. But that's just because I want to be able to tell other auditors, hey man, pick your sticks up, pick your shit up. When I say sticks, I'm talking about pencils, number 2 pencils with erasers on them. Pick your sticks up. Don't jump the gun. Oh, don't jump the gun? So you're saying a year or 2, it ain't enough? Give them about 3 or 4 more years. Fucking assholes, man. I'm gonna start yelling at other auditors for real. Look at how powerful it is if we just contact the states who are required to provide oral requests. If we do these phone audits, bro. No, they are out there fighting street cops. Well, here's the deal, bro. That's good. If you guys want to be cop watchers, no fucking problem. But while you're out there, serve the cop with a FOIA request, you dumb sluts. Hand the police officer while you're out there at midnight in the fucking street. Hand them a FOIA. How is it that these measly auditors are still doing cop watching without even serving the officer a FOIA? You dumb fucker. You're standing out there at 1 a.m., 2 a.m., and the cop is giving you lip. He's giving you shit. Tell him, okay, hold there. Take your fucking paper and draw your FOIA request on his windshield, on his hood. Put your paper on the cop's hood. Draw up your FOIA request and hand it to him. And take note if he takes it or not. What's normal? I got instructions for these auditors from every fucking angle, but it's like they're, you know, give them 3 or 4 more years. By that time, we're gonna be in the courtroom litigating better than the fucking attorney. I gotta train myself on how to say Give me 1 more year so I could learn how to say that properly. Cause that's what I'm gonna start telling these fucking lawyers when I go desk to desk with them, pencil to pencil with them. Right now I'm going pencil to pencil. I'm not even going pencil to pencil with FOIA officers. It's like they're in a fucking different lane. And some attorneys want to come cheesy and talk about FOIA to me. Give me 1 year just to practice on how to say Because like I said, that's what I'm going to be telling the attorneys. Give me 1 year just to practice how to say that. Okay. Interrogatory may relate. Interrogatory may relate to any matter that may be inquired into under Rule 26B. An interrogatory, look at James Freeman. I like James Freeman's work. I really do. But he's finally starting to pick up the statute of FOIA forward immediately. He showed a statute. It doesn't say the word immediately. But look at James Freeman, for example. Yeah, salute to him. He's good and all. But he still, 2 fucking days ago, he wrote down a FOIA form that he's requesting employees' names and salaries. James, how the fuck are you in this day and age requesting just name and salary? James, we need the real roster, James. We need the real roster. We need office phone. We need office email. We need location, work location. If they make me secretary tomorrow, I'm gonna tell auditors you're no longer of any service if you just request names of employees and salaries. You're measly. What the fuck is going on? Okay, What's Normal said, when I first started watching Number One Cops refused to identify. It's right here. Now they jump to even setting badge number. Complaints, promotions, demotions, termination documented on film. What's Normal? Give them 55 more months. Give them about 60 more months. What's Normal? Here comes KST. Many of those FOIA officers didn't know what FOIA means, especially the school district FOIA officer completely clueless about FOIA actually meant. Yes, they get paid $100,000 public money for no reason. Well, KST, I'm telling you to get out there in the field with scotch. Okay? Okay, so let's read this over here. An interrogatory may relate to any person, any matter that may be inquired into under, that's my favorite word, inquired under Rule 26B. Interrogatory is not objectionable merely because it asks for an opinion or contention that relates to the fact or the application of law to fact. But the court may order that the interrogatory need not be answered until designated discovery is complete or until a pretrial conference or some other time. Okay, no problem. Answers to objections. Responding party. The interrogatories must be answered. A. By the party to which they are directed, yes. B, if that party is a public or private corporation, a partnership, an association, or a governmental agency by any officer or agent who must furnish the information available to the party. Number 2, time to respond. The responding party must serve its answers and objections within 30 days after being served with the interrogatories. A shorter or longer time may be stipulated to under Rule 29 or to be ordered by the court. Number 3, answering each interrogatory. Each interrogatory must, to the extent it is not objected to, be answered separately and fully in writing under oath. Number 4, objections. The ground for objecting to an interrogatory must be stated with specifically. Any ground not stated in a timely objection is waived unless the court for good cause excuses the failure. Number 5, signature. The person who makes an answer must sign them, and the attorney who objects must sign any objections. All right, let me mention this here real quick, guys. Like right now, right? It's 1:25 a.m. in Chicago. It's 2:25 a.m. in Ohio. Why isn't there no auditors or supporters of auditors making phone calls to police departments 24 fucking hours that we already know the Ohio code? They're obligated to take your FOIA over the phone. They have an obligation. And why don't we have people calling right now requesting use of force, police brutality records right the fuck now from 2011, 2012, 13, 14, and so on and so the fuck forward? Why? Police stations are open 24 hours. I don't give a fuck who you're telling me got resolutions and solutions to how to better our nation. There's nobody they're gonna tell you hogwash. They're gonna tell you go campaign. They're gonna tell you wave the blue line flag, and they're gonna tell you hogwash and non-fucking sense. I'm telling you right now, FOIA is the way we're gonna get to the answer. And it happens in 5 days. It happens in 10 days. Stop slamming the desk. Now I dropped my paperwork. Let me stop slamming the desk. Okay. Katie says, I pretty much was left to defend myself. Last go around for my attorney, but was working for the other side. Yeah, attorneys work for the other side. Slow progress, but people are understanding, especially Tiffany Henryard, Storm Helen, where's our money going? Dalton was a sleepy, ignorant town. Now they are awake. Fuck them. Hey, Northwood, how's it going? Fuck them and fuck Benjamin Satan Yahoo. What's Normal says the people have some things in their favor. Communicating devices instantly, instant assembly. What's Normal? Yeah. Stupid fucking people out there, man. Okay. Alrighty. Moving forward. Alrighty. Misjoinder and non-joinder of parties, interpleader, class actions. Alrighty, so intervention, depositions, stipulations. Alrighty, we got past that. Request for admission. Your Honor, I'd like to admit my additional counsel here, the law firm of Blow Off Steam. Alrighty. Like look at what's normal. Look who decided to pick up the phone calls. Somebody from across the fucking pound. Somebody from the UK wants to do phone call auditings, while our measly people out here are auditors in Ohio, are auditors in fucking in Utah and all over the fucking place. Still are not reading their FOIA shit. Still they're not. When they start reading it, they'll be fucking excited. Look at that boy from Michigan, Public Tour. He's starting to pick up and read his shit. He's starting to say but then he's not using that stuff. He's still doing cop watching and basic shit. It's not just read this shit, man. I'm still waiting on Northwood Press to tell me when he's ready to do these phone calls. I went on Northwood's page about a year ago. I seen him looking at sex shit live. Now I'm not gonna lie, he put me onto something new. He was looking at Black Tape, the Black Tape Project, which I like that type of shit. You know, I'm a man, I love women, but that's not just all Northwood. We don't just need to look at ass and titties, bro. I need you, especially you do press, bro, to pick up these phones and start doing these Ohio calls. Northwood, you're gonna give me an opportunity to slap my desk one more time. I'm telling you right the fuck now, you're gonna give me another opportunity to slap my desk. So, yeah, man, just let me know when you're ready, Northwood. You know, let me know when you're ready, man. I'll give you all the instructions. He said, I'll come up on your panel with you and call on your channel. That won't work, bro. That won't work because well, it could work. I would have to patch you in through the phone, but it almost won't work because I'm dialing off of my cell phone on speakerphone. I could give you the instruction. I don't know why you wouldn't want to do it on your page. Unless if I could give you the instructions, bro, I could give you the instructions and you could do it on my page. Yeah, that's not a problem. He said, any update on the crazy lunatic mayor that was complaining about his husband? Oh, that's not my story. That was somebody else's shit. The only thing I'm gonna do a babysit treatment for that goofy fucking mayor. Next week, 2 more weeks, a month from right now, I'm gonna do a scrape up of all the bootlickers that sent him an email and all the people disrespecting that fucking psychopath. So, oh, okay, that's pretty cool, Northwood. But we need you to do these phone calls too, bro. We need these phone calls. Now, Northwood, let me ask you a question here. Do you have a laptop and a computer? I mean, a laptop or a computer and a cell phone? So my question is, do you have a laptop or a computer and a cell phone? 2 devices. And then I'll tell you what the next question is. Yeah, because if you're serious, I'm going to put you on the fucking phone right now. I'm going to hang this up and I'm going to put you through StreamYard. And I'm going to have you make these calls right now. Right now. Oh, just your phone. Then it ain't going to work. You see what we're talking about? You see what we're talking about? You got to have an additional device, bro. Alrighty, let's keep scrolling. Man, I wanna have a chat with What's Normal too, man. He got knowledge. He or she, I don't know who that is. Alrighty, right of jury trial. Go on my stream, jump on with me, let's do it live. Well, wait a minute. Are you saying you want to jump on a stream on your cell phone or your computer? I thought you don't got a computer. So you want to live stream on your phone? And you want me to make these calls in my voice on your stream? No, bro. I want you to do the calls. I got more than 100 phone call auditing alone. Oh, Katie. Oh my God. You live in Ohio. Katie, we called, I think we called Ironton, Ohio earlier with another channel. Oh, Northwood Press says I'll do them. Okay, I'm trying to figure out how we could facilitate that, bro. If you only have one cell phone and you're gonna be on StreamYard on your cell phone, there's no way you could do these calls, is what I'm saying. Do you have two cell phones? If you have two cell phones, then you could do it. You have to have two devices. Yeah, Katie, so here's the deal, Katie. In the entire state of Ohio, with what we're talking about is 8,000 plus government agencies in Ohio that have to, can't get away with it. They shall honor your oral request. This means, Katie, I want you to call 20 agencies within 1 hour. And I want you to request a few things from these agencies. I want you to request miscellaneous credit card statements from the city. We want to look through their money. And I want you to request police use of force records from their police department. So each phone call for each city is going to take you less than 10 minutes. The beautiful thing is the Ohio Code, which says they're not allowed to ask you for your name. They're not allowed to ask you the purpose why you're requesting this stuff, unless they first inform you that written request is not mandatory, and then you could decline to provide your information. So the Ohio Code is almost the very best when it comes to that portion. I'm gonna go with Illinois Code is the fucking best, bottom line. But second in class is Ohio. And I'm telling you, Katie, when you're ready to start making these phone calls, and we especially need a female voice on there, it's soothing. When you're ready to start making these phone calls, we're gonna set you up with a channel. Katie, here's the first thing I want you to do, Katie, if you're really serious about this. Start a YouTube channel tonight, and on your computer, on your desktop or on your laptop, not on your cell phone, go after you make a YouTube channel, click on the live feature. You're gonna activate your live. It's gonna take 24 hours. Once your YouTube channel is ready to go live, I'll tell you what the next step is. Send me an email and tell me you're ready. We already had 3 other people in the past do these phone calls, but I never heard from them again. They only did it 1 time or 2 times. I don't know where they're at now. But and one of them was an auditor. But we need people to constantly do this shit, man. If you could do 1 session per week, or at least 1 session per month, which 1 session would be an hour to an hour and a half, that would be more than you fucking believe. Because if you're able to get a hold of 8 agencies, that means there's 8 agencies in the next 10 days going to send you from 10 different police departments. They're going to send you use of force records and police brutality from 8 separate police departments. In 10 days, you're going to receive all that info. Now we need more people to look through that info. And we all look through that info together. This is just a start. We need to train people's minds and to start obtaining these things. We need to backtrack. We need to dig in the crates. I got the solution. I got the resolution. We all got access. We all got the energy to do this. We have to work together. What's normal? Click on Katie's page and tell me how many subs she got, bro. Oh, you got a backup channel ready to roll. Just give you a few days to set it up. I have 2 cell phones and a desktop. Will that work? That's perfect. That's perfect. Now, the next step, Katie, on your other cell phone, on any cell phone, download an app called Text Now. When you download an app called Text Now, I'm going to type it in here. Text Now. This application is free, and it's going to allow you to create a cell phone with any area code you want. You could even use a Ohio area code. It'll give you a number, a free number. You would just have to connect your phone to the Wi-Fi from your house, internet, and you could use that. It's like a burner phone number. You know what I'm saying? So yeah, get your live stream going. That's the first step. Okay, you got Text Now. Beautiful. Now the next step and the final step is create an email, a brand new email just for these phone calls. Could be Gmail, it could be Proton, it could be anything you like. So those are the first 3 steps. Get a YouTube channel, make sure you go live 24 hours in advance. Get Text Now as the second step. The third step is going to be to create a brand new email just to keep track of this shit moving forward. And there's another additional thing that's very simple. Those other instructions I will talk to you briefly over the phone. Shoot me over your messenger or your phone number or something. I'll call you and I'll explain to you what's the next steps, so we could move fast with it. We've got to move fast with it. Since you got an additional cell phone, I'm sure it's a smartphone. Now Google has a microphone tab. Let me show you how I do it. I say, for example, here I click on this microphone button. It's like Siri, and I speak into the mic like this. Watch this. Cleveland, Ohio City Hall phone number.
You can call Cleveland City Hall at 216.
Okay, it's so fucking quick. Now you see how Siri or this Google gives me the number? Once I say those 4 or 5 things, Google automatically gives me the number for me to click on. Once I click on that number, it automatically calls them because it's linked to Text Now. So it saves so much fucking time. And we could zip through it. We could zip through it and get to the bottom of it. And I'm telling you, there's some employees that are going to give you slack, but you're going to have the code in front of you. And one great thing that we're building here is we're getting to figure out who these employees are, how these employees respond. We're gonna see these miscellaneous money, where our money is going. We're gonna see what these cops have been doing. I mean, the list goes on. If you want to request additional things, if you want to request damaged water meters, if you want to request records of your fellow neighbors who have extensive water bills, if you wanted to request, the list goes on. The last 10 employees that were fired. What was the reason why they were fired? Any employees who have been committed fraud. The list goes on. How much money to the penny is going to fund the genocide overseas? The list goes on. The list. Slapping my table. Tommy V. Where's Tommy V? I don't see Tommy V. Alrighty, let's go ahead and carry on here. So yeah, man, anyway, I did enough yapping. We'll get to this at a later time. I know New Normal wanted me to look at it at one here. Maybe New Normal, if you tell me what that was real quick, we'll sign off with reading the one you're into. Oh, so Northwood Press, what are you trying to do, bro? Yeah, Katie, I'm telling you, man. I really fucking think that these phone call auditing is a special niche, and the more people start doing this stuff, it's gonna have a big fucking impact, man. I really do believe it. Because the people, they really like this shit. I remember last year there was a bunch of people heavy on this shit. When I did calls for like 15 days in a row, every day faithfully. Ass early in the morning, I was doing phone calls because at that time my schedule was flipped over, and I had time at that time. But what I'm telling you is we have to get on these phone call auditing, man. It's so important. It's so important, and nobody's doing it. I'm telling you, 0 people out of the fucking world are doing it. Satire. No, it's not satire. Okay? It's very important, guys. Please pick up the utensils, man. That's the sound of me drinking ice cold water out of a gallon. Crystal Glacier. Nah, this is from the Dollar Tree. Crystal Geyser. Okay. Oh, that's what's up, man. She says this channel is just where I post comedy stuff. Alrighty, so you know what, Katie? Let me click on your. You see what I'm talking about, Northwood Press? I don't know what you're on, bro. You're trying to do these phone calls or what, man? Alrighty, let me go to Katie's channel. And, yeah, you know what? Yeah, Katie, you already got 127 subs on this channel. It looks like you're ready to go live, or maybe on your backup channel, but whenever you're ready, man, whenever you're ready, I'm ready. We need people doing this stuff, man, all day, every day. Man, I swear to God, I'd rather watch somebody do phone call audits nowadays than a fucking guy going and doing a post office audit. We're educating the people. We're standing up for our rights. I'm in a post office looking for poster 7. Fuck that stupidity. One person like Katie does 10 fucking government agencies phone calls. That's more valuable than a fucking odd rod looking for a poster 7 in a late year. We're teaching the people on our rights. No, pick up the fucking phone and teach these employees of their job to begin with. Then teach the people of their rights. And then on top of that, we're getting data. In the next 5 to 10 days, we're getting data. Oh my God. How's the okay, anyway. Yeah, I think I'm eligible. I did a reading. I'm eligible to do a no, you have to have 1,000 subs to go live on your cell phone. But you could start a brand new channel and you have to wait 24 hours to go live on your computer or on your laptop. On your computer or laptop, you could go live immediately after 24 hours when you start a brand new channel. But you can't go live on your cell phone until you got 1,000 subscribers. It's a little silly, but like Tupac, that's just the way it is. Alrighty, anyways, guys, I think we're going to be signing out here. We did a good read. I'm going to start a session right now, probably music. I'm going to start a musical session in about 5 or 10 minutes. So make sure you refresh your browser and let's see if we create an album. The one who encourages you to out of the NH Mountain.